John says, well, he says a lot here, but I'm going to try to condense it down a little bit. He's talking about Thomas being frustrated with the lower courts after Heller and McDonald, which, yes, that definitely comes across in this ruling. And, he's saying that effectively, he was saying in most jurisdictions, especially the Ninth Circuit, effectively became a rational basis test where just about any gun control legislation that was put forward by legislators was upheld. This is a common critique, right, that you've seen of federal litigation on guns over the last decade. And this is one of the reasons why gun rights, this is why Thomas kept referring to the right as a second class right. The idea was that especially in the Ninth Circuit, I don't believe they ever struck down any of the gun regulations in California or in the entire circuit. So
not to date.
They had this two-step process a lot of lower courts were using that Thomas said was one step too far, which basically the first step was to identify whether or not the Second Amendment rights were implicated in by the law. And then the second step was to use a balancing test to determine whether or not the state had, usually they would use intermediate scrutiny, although many people, basically criticized and said they were effectively using, as John says here, rational basis, which is an extremely low standard for
shorthand is government wins. That's the shorthand for rational basis review. Yeah.
And, intermediate scrutiny is supposed to be a level above that, which is that the government has to identify that they're do you remember the exact?
The law is narrowly tailored for a compelling government interest.
Yeah, compelling government interest, right? And but a lot of people argued that they sort of threw out the narrowly tailored aspect of that test oftentimes, because you're talking about things like, again, total bans on categories of firearms,
or handgun rosters,
and the intention is to stop violent crime that's committed by a tiny percentage of the population, but you're banning everyone from owning this class of weapons.
Right.
Anyway, that has always been the critique, but he points out, so he says, moving to this new test, he calls it text history tradition, but I think really it's just text informed by the tradition during the founding era, right?
Yeah.
That's and maybe the era of the 14th Amendment.
With a special emphasis on text, Thomas made very clear that the text was key in this. So if something implicates the text, it's presumptively lawful, was kind of his big thing.
Unless there's an analogous regulation that fits into the tradition of gun regulation during the era where the Second Amendment and 14th Amendments were ratified. But so it's not strict scrutiny, it's below that, but it's above intermediate scrutiny for sure. And Thomas and the court would say it's a rejection of these balancing tests altogether.
Right.
But anyway, John's point here is that this new standard, the problem with it is that it seems just as subjective. And he says, creative legal minds can pour through history to make all sorts of arguments that can be used to uphold even the law struck down in Bruin. Reading some of the amicus briefs for New York, you can see such appeals. While not convincing to the conservative court, won't we just land back in the exact same situation where liberal circuit courts will rubber stamp any old gun control policy? And we wrote about this a while back when some of those briefs were being filed. We wrote about the one he's talking about, actually. And this is one of the weaknesses with this new test, is that it's still fairly subjective. Like, what exactly does it mean for a law to be analogous with something that was in place, during the founding era that fits in the tradition of gun regulation, right?
Right.
And
how narrowly tailored is your definition of analogous going to be? Because you could be some pretty strained definitions of analogous and say, oh, that's about the same. And so. Yeah.
And this is something we were alluding to earlier. But absolutely. I think what you'll see is that the lower courts are just going to adopt this new a new kind of language for justifying the same,
essentially the
outcomes that
same,
they had before. And they'll say, because the court isn't saying here that you need to have an exact match for the regulation to be constitutional. So you don't need to have a ban on the sale of machine guns to civilians from 1792 for the law to be upheld as constitutional. Instead, you just need regulations on unusual and dangerous weapons. Right? They've talked about that a lot. You don't need for the National Instant Criminal Background Check system to have been in place in the 18th century for that system to be presumptively constitutional, because it's designed to ensure that people who are shown to be a danger to themselves or others aren't able to buy guns, which is, again, another thing that was, broadly part of regulation at the time of the founding. They tried to keep dangerous people from owning guns. They tried to keep certain kinds of unusual or dangerous weapons from public circulation. Right. And so you're going to find a lot of ways to justify that sort of a lot of modern laws under that reasoning. Right.
That's where our sensitive places struggle comes from, that we were just talking about with New York. Right. That's why they're testing that limit, because at the time of the founding, there were sensitive places restrictions at like polling places, for example. And New York saying, well, maybe we can stretch that analogy to cover most of Lower Manhattan or whatever, So that's kind of where this fight comes down to, is how is a judge going to read that?
Exactly. And that's exactly the thing I think people on having, very strong reactions on either side of this are missing about what's about to happen here, which is why I keep emphasizing that if the Supreme Court wants these lower courts to rule in the way that it wants, that it expects, it's going to have to step in probably a number of times before they're going to actually reach that. I mean, look at what happened in Heller, right? Heller came down and it established the Second Amendment as an individual right. How many laws were actually struck down because of that? I mean, not many. Right. Realistically. There were only a couple handgun bans in effect in the whole country at the time. I don't know if historians can, or somebody who knows a bit more than me on this can maybe chime in the comments or something. But Chicago and DC might have been the only total bans on handguns. There might have been one or two smaller ones somewhere in other cities, but the biggest effect, and we've written about this at the Reload, of Heller and McDonald really came to stun gun bans, and that was because that only happened because of Sertano v. Massachusetts, which was a 2016 case that was basically just a 2-page ruling that said yes, stun guns are protected by the Second Amendment. And that led to a lot of stun gun bans getting struck down, although it took years of filing cases to do that. But so what you'll notice about that trend is the only laws that were consistently wiped from the books after Heller, McDonald, and Sertano were total handgun bans and total bans on stun guns. So now it seems to me what's most likely to happen, if the Supreme Court does nothing else at all, is that all the circuits that have been upholding these gun restrictions over the last 12 years are going to continue to do that, except for when it comes to may issue gun carry laws. Yeah. The exact specific regulation that the Supreme Court has now struck down. Yeah. So I think that's what a lot of people are missing. The only way this extends, you could be wrong. Maybe this Ninth Circuit will see the light now, and suddenly, even though there's plenty of reason to think that they could uphold a lot of these under historical precedent, or at least make the argument. I mean, like you said, that argument for why New York's law was presumptively constitutional or had this historical tradition wasn't like stupid. It wasn't
Right.
completely ridiculous. It wasn't necessarily ultimately convincing, but
Right.
you could find laws that are
Right.
somewhat analogous. I think they misrepresented some of that stuff, and that got them in trouble. But regardless, that's the point. Is like you could still see a lot of these being upheld. It wouldn't shock me. And I think John's hitting on a very good point here, which is like, go look at Duke Firearms Law Center. Look at their historical database of gun laws. You're going to find a lot of stuff in there that could easily be used as like, this isn't an analog, or like broadly speaking, these are similar ideas of regulation. And so, I think that's what the lower courts that are inclined to uphold stricter gun laws are going to now go to.